Good evening, friends. I see Archana Jain along with CA Navjot. Welcome you all on this webinar on how to deal with summons and notices. What exactly are these summon and notices are, and when you have received these kind of summons and notices, so how to move further and how to take care of these summons and notices. This will be dealing in this webinar today. So for this, I will request Navjot to initiate the proceedings for this webinar.
Yeah. So, good evening, everyone. And as you know, like today's topic is quite interesting one and quite relevant as well in today's time when we see especially the Indian taxation structure, which is quite complicated and a lot of complications related to judiciary interpretational issues are there. And the issues in India, like they take long, they take a very significant time, to get disposed of. And in especially in GST, I would not say it's a badly drafted or badly interpreted law, but yes, we are facing some issues now on either our side or on a department side. So we are on a verge of a war, like regarding every sort of provision which is in GST related to ITC. It is related to adjudication. So there are a lot of complications and a lot of tussle is going on, and that at this point of time it becomes very important when we take these Shokos notices or summons which are being issued. Like uh, like there are plenty of notices which are being issued. I have observed like they are issuing notices even per month wise as well. A client have received 12 notices for, like, for his each month, each notice. So then it becomes very important how you deal with it, and whenever any notice comes, what precautions or how you should see it and how should you respond to it. So today we have given this opportunity to tell you about all these things. Now we have divided this today's webinar in two topics, two major points. One is what is Shokos notice and what is summon. And it is respect to, I would say, in every tax law. It's not related to GST. You can take the idea, like, because since Shokos notice is kind of a natural justice which is being provided to assessees or maybe to the department side. It is not just for the assessee, but it is a natural justice remedy which is provided to you, that your side also will be heard before any proceedings or before taking any decisions by the revenue side. And second, we'll deal with the how should we be dealing with the Shokos notice and summon when these are being served. So let's
Navjot,
start.
before you start with this show cause notice, I just wanted to intervene in between. Nowadays, we have
Yeah.
seen that we are not just receiving the show cause notices, but as lightly I usually says, we are also receiving the communication, intimation, or the letters, basically for the roving inquiry or something related to only they are demanding some kind of data from you or some kind of information from you. So all these things has to be taken into legal parlance and they have to be dealt with very serious issue. I think these are serious issues and we have to contest and we have to deal with each and every kind of communication that we are receiving from the department per se. It should not be that
Great.
okay, until unless we are receiving a show cause notice, we are not going to reply to those communication. So that should not be there. Whenever you are receiving some intimation or any kind of communication from the department, I think we both are on the same page that we should be giving some kind of reply to them. Whether we agree to their contention, whatever they have asked for, whether we agree to that or we don't agree to that, but at least there has to be some kind of reply to that so that tomorrow there should not be any repercussion for the non-compliance of that particular communication from the department side.
Right. And adding to you what you said, that whenever we interact with the department officials as well, they also say that I think it's you, the consultants, which suggest client not to reply. So that's not totally true. It's something which I suggest from the day one, that uh, whether you need time, whether you want to contest it, whether you want to agree to it, you just keep everything in writing. Now in today's technological world, you can keep it on the mail as well. So you have a lot of options for doing it. Even I have seen like many officers are even cooperating that they are taking the data on WhatsApp as well if you're not able to. So if they are cooperating, so we cannot blame them for everything. And at some point of time, I've seen like clients are also being I would say clumsy enough that they are not responding to these notices. They think that it's a notice and we'll talk to them over the call and we'll just settle it down. That's not the right approach, I would say, because since in that case your file is still open with them, even if that officer who was taking care of the file might get transferred in a meanwhile, still that file is not closed. So you have to get it closed, you have to get the order done in your favor, or might be in a, you just have to get an order, be it like adverse or in your favor. So that's
Yes.
why these terms are important.
And it should not be treated at par with your direct tax compliance, because there is a difference between the communication that you're receiving in your direct taxation aspect and what you are receiving in your indirect tax aspect. So there has to be some kind of distinction, and this has to be dealt in a different manner also.
Exactly,
Go
exactly.
ahead. Yeah.
So, as far as taxation laws are concerned, so I just have a one quote for all these taxation tax laws are which is, tax laws are basically the most imaginative fiction being written today. Why would I say that? Because since if you see the GST law, you see a lot of provisions. When we read it, we think of a different perspective that yes, this is in a favor of client, this is in favor of assessee, this is in favor of taxpayer. But when we see the observations of the audit wing, like in today's time, you see that a lot of audit observations, a lot of departmental audits are going on. So you see their side, you see their way of thinking, be it like classification issue, be it like ITC issue, transitional credit issue, whatsoever the issue is, you see a lot of gap between both of the thinking, both of the mind. So I would say this is kind of very much imaginative fiction when we talk about the GST law per se. Now, what is Shokos notice, and how does the legal principles play a very important part when we talk about Shokos notice? So there is a legal principle which is audi ultram partem. Now, what is it? It is a time-tested principle of natural justice, which means let the other side be heard, that no person can be adjudged guilty without being given an opportunity to answer charges against such person. So whatsoever it is in your favor, it is in department favor, whatsoever it is, you will not be charged as guilty unless your side is also being heard. Now the thing is, whenever we talk about adjudication, this is a cassette's B side, because since till now what you have done is you have taken all the decisions, you have filed your returns, you have given the data to the department whenever they asked for any information. So this is cassette's B side, when they analyze what you have already done, and then they apply their mind, they apply their interpretational knowledge. And I don't say that every time they're wrong. It's not about right or wrong, it's not a right or wrong theory, but it is something that on a particular point, when we read a document, when we read a law, there might be different interpretations to different things. So then all these things and all these notices, intimations becomes important. Now further, and to hear a person, such person should be put a notice which clearly states various aspects about the charges or allegations in such notice, so that the person can understand the allegations and answer them. So it is just not that you have find an allegation, you just send a notice, and that notice can be vague and it can be in any form. That's not the point. You have to tell them, you have to tell the taxpayer what is the clear allegation, and so that he'll be able to answer to those things. Now second legal principle is sine qua non. Now in GST, as with every legislation, this notice is called Shokos notice, and this Shokos notice is mandatory requirement for raising demands. Any other communication, letter, endorsement, suggestion, or advisory from the tax department which we generally receives on a day-to-day basis cannot be considered as a Shokos notice. Now there is a Supreme Court judgment as well in the Canara Bank versus VK Avasthi, in which it was extensively put on an effort on the principle of natural justice. So it is very important, and you see a lot of judgments by the High Court in which the principle of sine qua non is being taken into consideration, wherein it is being said several times that for demand proceedings, Shokos notice should be there, and it sets the law in motion. Now, when we talk about demand, so Shokos notice is only necessary when demand will be there, or there will be Shokos notice which will not be containing any sort of financial liability as well. So there are some kind of activities in GST which, if department will be doing that, he will have necessarily to give you the Shokos notice, and there are forms have been prescribed in this regard. Now, what can that be? There might be proceedings under section 52. There might be proceedings under section 73, 74, and 76. And whenever any penalty is being levied under section 122, any interest is being levied under 50. We'll talk about the interest part later on. It's a bit complicated at this point of time. Levy of penalty under section 123, and when there is a general penalty under section 125, and when there are specific cases when penalties levied under section 127. But basically, whenever they'll be levying any sort of penalty, they'll give you a Shokos, and to give you a chance that why this penalty or why this tax or why this interest should not be demanded from you. Now, apart from that, if we talk about the financial, non-financial aspect, whenever any cancellation, they want to do any cancellation of your registration under section 29, then also they are required to give you a Shokos notice in REG 17. And when you file for a revocation and they reject your application for revocation of cancellation of registration under section 30, then also they are required to give you a Shokos notice. Apart from that, whenever they are going to reject your refund, then also they are going to give you a Shokos notice. Apart from that, whenever they do the assessment of an unregistered person in ASMT 14, then also they are required to give a Shokos notice. So this is the format of Shokos notice only, ASMT 14. And apart from that, we talk about GST practitioner concept. In that also, if they want to disqualify any person from being a GST practitioner, then also they are required to do this. And there are revision proceedings as well prescribed in the section 108. In that also, whenever any decision is being taken, they are bound to serve you a Shokos notice. Now, is there any possibility, is there any event when the Shokos notice is not required to be given? That is in the case when best judgment assessment is being there for non-filer of returns under section 62, because since whenever they do the best judgment assessment, before that as well, they have given you a lot of chances to prove your side. So at that time, it's not viable, a separate Shokos notice is also required. Now, apart from that, if we read the law and do the plain reading, so you might be finding that for payment of interest also, they don't need to serve a Shokos notice as well. Now, there are some contrary views to this as well. There are two key judgments in which it was held that Shokos notice is mandatory even if interest is being demanded from the assessees. But till now, after getting all these high court judgments, also what we see is in practical ways, we see that people are doing this way. People are the department officials are sending notices, Shokos notices, or they might be sending. There are few officers who are directly sending the demand notices as well, just without Shokos notice. So there are a mix of both the interpretations when they do read section 50 and the collection mechanism of interest from the department side. Now, apart from that, there is a key judgment when we talk about Shokos notices. This is I would say, a landmark judgment when we decide that what to do with the Shokos notice. That is, Shokos notice is a foundation on which the department has to build up its case. If the allegations in the Shokos notice are not specific and are on the contrary vague, lack details, or unintelligible, that is sufficient to hold that the notice was not given proper opportunity to meet the allegations indicated in the Shokos notice. Now, what you find when you get the Shokos notice, what this judgment says, that Shokos notice is the foundation of initiating any allegation or initiating or build up a case against any taxpayer. Now, if that particular allegation is not specific in that Shokos notice, and if that Shokos notice is vague or lacking detail, or it is kind of they have not applied their mind while drafting it. So if allegations are not clear in that notice, so that Shokos notice becomes invalid. So that's how this judgment tried to explain to us. Now, apart from it also, why Shokos notice is important, and there are few Supreme Court judgments in this regard. In Madhumilan syntax, it was held by Supreme Court that any demand raised without issuing Shokos notice or granting a hearing would be invalid in terms of Section 11A of Central Excise Act 1944. So that's what they said in a pre-GST regime as well, that even if any demand is being raised without Shokos notice, that would be invalid. In Cosan Metal as well, the Supreme Court held that Shokos notice is necessary before adjudication. Mere noting in periodical returns is not a notice. So they said that if you are merely noting something in your periodical returns which you are filing every month or every quarter, then it is not sufficient. You'll have to give them a Shokos notice with proper forms and contents. Apart from that, there are two more cases of Balarpur Industries in which Supreme Court held that Shokos notice is a foundation in the matter of levy and recovery of duty, penalty, and interest. Where certain matter has not been invoked in the Shokos notice, it would not be open to central excise officer to invoke the same and subsequently. Now, from this judgment, you might get an idea that this particular Shokos notice will be containing a financial aspects like levy, recovery of duty, penalty, interest, and the certain matter as well, like why this is being invoked. But there might be chances why this Shokos notice is important, because when that central excise officer will be drafting the final order, so he cannot put some new grounds or new things into that order. So he'll have to be bound by that. Now, further in Supreme Court judgment in Toyo Engineering, it was held that where a certain grounds were not mentioned in Shokos notice, the department could not travel beyond the Shokos notice. So it's basically like that. It is kind of a bounding you to just it is bounding you to keep in limits. Like whatsoever written in the Shokos notice will be prima facie be applied to the order whenever they will be drafting order, obviously after taking your side as well. Or if it is a ex party, even if it is ex party order, then also they cannot include some new grounds. Okay, so that's how it is. Now when we talk about Shokos notice, obviously it will be sent by someone. So who will send this? Now there is a proper officer definition which is given in section 2 subsection 91, which is read with circular 3 2017, in which commissioner of central tax or officer who has been assigned the function by commissioner in this board will be the proper officer. Now he may assign some powers to some or may delegate some powers to the some other officers as well for issuing the Shokos notice, and like they might decide some monetary limits as well, that up to the matter of 10 lakhs, 20 lakhs, superintendent will be allowed, up to 10 lakh, inspector will be allowed, and above 50 lakh, assistant commissioner would be allowed. I'm just taking in a rough example to just make you understand that first thing what we understood is what is Shokos notice, what is the why it is important. Second, who will be sending that notice. Whenever any Shokos notice comes to you, you read it like it contains the basic principle, or it I would say qualify the basic principle as per the Supreme Court judgments which we just discussed. Second, you just see the jurisdiction, or I would say the power of issuing that Shokos notice. So you can see that circular in which that power must be given. If it is a ITC matter or it is a detention matter, so if that person whomsoever have issued you a Shokos notice, so see if that person is even authorized to do that. Now this is just one side of the Shokos notice, that whenever they issue it. Now the service of Shokos notice is also important. Service of note, when we talk about service of notice, that means service means giving legally required notice to other parties that you may have filed paper asking for a court order that may affect them. The court papers can only be delivered in a manner permitted by law, and proof of delivery must be filed with the court. And why it is necessary to serve a notice to other parties? Here in this is a basically except from I would say what is service and what is how it becomes important. Service basically means, when we talk about in I would say the court era, that in which we need to give that document on the basis of any proceedings which are going to initiate. We need to give that document to the other party, or the party whose side we need to be heard. So that's why it becomes important to listen to their side, and that service of notice, that giving it through a mode which are prescribed in law, that it would won't be like that the official gave the notice through any means which is not even prescribed in the law, like they are sharing it over the WhatsApp. Even if suppose if they are sharing over the WhatsApp, and the person whomsoever received it challenges to this, because since that method is not prescribed in the law, so you can challenge all these things and you can contest these things, that I have not received the notice and this is not the correct way to communicate with the taxpayer. So there is a obviously there is a mechanism in each law, but in taxation, in GST, if we talk about, there is a section 169 of CGST Act, CGST or SGST Act. Now, what does it says? It says if you're serving directly or by messenger, like a person is going and serving it, if you're serving by post, if you're serving by email, if you're serving if you're uploading it on the GST portal, if you are giving it in a newspaper, if you are affixing on a conspicuous place, like you might get it placed. If you must have seen, if you have visited the department, so there sometimes there are Shokos notices on the notice board as well. So that's what it means. Sometimes if any person is not there, so they can affix it on the place of your business premise. They can do that. Now, apart from that, there are few jurisprudences behind us that word service as well. Since it is important to communicate, obviously there will be some issues as well behind that. So there are few of the matters which Supreme Court have tried to dealt with. Now there is a judgment of State of Punjab versus Khemiram, in which it was held that the word communicate cannot be interpreted to mean that order would become effective only on its receipt by a concerned government officer. Communication is once the order is put in course of transmission and thus go out of the control of authority issuing it. So they are saying that whenever you dispatch that communication or the notice, then it would be termed as it is being communicated. So, if you read this judgment in detail, so what they're trying to do is, when these officers try to share all these notices with people or the taxpayer, sometimes they take the ground that I did not received it, or maybe due to some reason I did not receive it. So there might be a lot of I would say excuses sometimes which taxpayer makes. So then a literal meaning of service, like giving it in the hand, that is the literal meaning of it, like then it would defeat, obviously it would defeat the purpose of Shokos notice, because every time you'll come up with the excuse that I did not receive the notice. So for that, there was a judgment of VRA Cotton's Mail Limited, wherein Punjab Haryana court said there was a previous judgment as well, Banarsi Devi of Supreme Court, in which it was said that the word issue and service can be used interchangeably. Like whenever we read the word service or whenever we read the word issue, we can interchange these words. So whenever we see the words serving, that the serving of notice is important, we can read that meaning of service as a issue in a place of issue. The reason being, when you try to use this word, or you try to defeat the purpose, or you try to I would say befool the government by coming up with the excuse that I did not receive the notice, it is for them. Then these provisions or this term are getting used interchangeably. Now, apart from that, in GST, there was an interesting judgment in Kabir Realty Private Limited of Madhya Pradesh High Court. Now, this is something which we are discussing, that how a Shokos notice and in what form they are getting issued. Now, in this particular judgment, the assessee filed GSTR1 returns, but he did not file GSTR3B return. Now, after that, the department initiated the proceedings under Section 79 against the assessee. Now, what court have decided that since you have filed GSTR1, so that's how somehow you have shown the liability. Okay, you have passed on the credit, obviously, but you did not pay the tax. But filing GSTR1 is kind of a showing your liability. So that's how the proceedings initiated under Section 79 becomes valid. So in this particular case, a separate notice was not given to the assessee. Only The department acted on the behalf, sorry, I would say the department acted because you filed a GSTR1 return. They saw and they quantified the tax liability as per the GSTR1 return, and they started the recovery proceedings. Now, what would be the form and content of Shokos notice? What would be the parts and areas which Shokos notice must cover? The first would be the facts of case, like what are the facts of case, and apart from that, relevant provisions of law and discussion on the limitation period. That if department have gone for extended limitation period, and what do we mean by extended limitation period is in taxation laws there are kind of two periods in when we talk about particular indirect taxation. In this there are two kind of limitations. One is for bona fide people who make mistakes, and second one is for fraud people who make mistakes intendedly to evade the duty of tax. So for the second category, there is an extended period of limitation for issuing the notice. Like in GST per se, it's 5 years. So department have some more time to, I would say, scrutinize or make their case more strong and just to curb all these fraud assessees. Now, if extended period of limitation is being invoked, so then the department will have to show and discuss on the limitation provisions as well, that why this extended limitation is being adopted. Apart from that, there might be findings from earlier verifications, cause of proposed action. Like Shokos notice must clearly state that what would be the course of action if we do not comply with the Shokos notice. Apart from that, the grounds which the department have relied upon for proposing additional tax liability or actions whatsoever he is going to take. Apart from that, any specific allegation or charges with evidence they have to show, and you have to give the justification for how and why taxable person is liable to pay tax. Consideration and appreciation of evidence is produced. Details of contravention of act and rules wherever necessary. Now, whatever the list which I've just read, it is not exhaustive, or I would say it's not a legal list which is mentioned in anywhere in the law. But to form the basis that the department did not use the predetermined mindset, or they were bona fide on their part, or they have done their case properly. Obviously, when I talk about that Brindavan beverage, the case law of Supreme Court, in which they said that Shokos notice is a foundation. If the foundation is not there, if the foundation is not strong enough, obviously you cannot give me the final order. Obviously, when Shokos notice is invalid, then there is no question of allegations. So first you form that basis very strongly, you form that foundation very strongly. That's why it becomes very important, and you would be seeing in practical experience that many people are challenging the Shokos notice directly to the High Court. They don't even reply to Shokos notice; they just directly go to the High Courts. So Archana ji would be taking care of that point. That how can you go and what would be what are the jurisprudence behind that course of action. Now these are just the points which you need to take care, and you can challenge it as well when you reply to the Shokos notice that the learned officer have not applied his mind well in reading this provision, and why that allegation is wrong. And if he have not written something clearly, you can mention that as well while replying to the Shokos notice, that yes, you did not mention this provision, and why this is a contravention, and why you have applied this section 74 on me. So these are the things which department need to take care, and you also need to take care when you receive any Shokos notice. Now, apart from that, there might be some discussion on legal issues as well. They might be giving you some, previous judgments to forming their belief, and quantification of proposed tax interest and liability is very important. And date of hearing for giving opportunity must be there. Obviously, there will be a hearing, because whenever you will reply to them, and obviously you will be given opportunity of hearing, wherein you will make them understand what you have written in the Shokos notice. And apart from that, indicating clear message that it is a prima facie opinion proposal and not a final opinion, and the reply will be considered in effective manner. Now, why I have written that, if you receive a Shokos notice, which I am like saying it from past 30 minutes, that Shokos notice is kind of a natural justice remedy which is given to you. Now, if you read on the Shokos notice, if you prima facie see that opinion or proposal, and you feel like they have already applied their mindset, and they are already with that mindset that they will give me an adverse order and they will not consider my reply, so then also it becomes a very important that you can challenge that notice even before the high court as well, under the article 226, that you are not given the proper natural justice. That officer or that quasi judicial authority has come to you with a predetermined mindset that they will be taking their action irrespective of whatsoever you reply. Now, in this regard, there was a master circular as well when we talk about Shokos notice adjudication recovery. Since a lot of notices and circulars, and I think there were 92 circulars and instructions on the Shokos notice and adjudication which were issued by the board time to time. So they somehow tried to sum it up, and just for easing assessees and the department officials as well. So they issued a master circular in March 2017, just before the enactment of GST Act. Now, apart from it, when we talk about the legal sides and what is the legal principle of Shokos notice and the purpose of issuing serving the Shokos notice, let's come. We have discussed that what would be the form and content of the Shokos notice. Now, apart from that, even if content is okay, so we have passed two steps. First, Shokos notice is fine. It is clearly stating everything. Second, it is having proper form and content, and it is giving you a right picture like what department is trying to say to you. Now, third step comes. There is a concept of document identification number. Now, what is it about? Since a lot of officers, or I would say a lot of there were some fraud people as well who were impersonating themselves as officers, and they were issuing the notice to the people, and they were extorting money like that. So just to streamline whatsoever notice is being issued from a commissionerate, they came up with the idea of document identification number. It's kind of a code which is given individually to each Shokos notice. They issued a circular of 128 in 2019, in which they said that whenever any communication will be given to the taxpayer, then it will be required to quote DIN. Now, there is a mandatory requirement of DIN on any Shokos notice, because as per this circular, whenever any communication and a notice which is sent through a physical means by post or maybe by emails is not bearing the proper DIN, then that particular document becomes invalid, and it would be deemed that it was never issued. So even the finance minister also said in his speech that whenever any document which you receive from the CBIC officer and it is not bearing a DIN, then you can very well put that document in the dustbin. So that's how it means. But there is a but behind this the whole concept. Whenever you try to tell the department official that yes, this you have not mentioned the DIN, though you have drafted the Shokos notice very well and everything is fine, but DIN is not there, so I'm not considering this Shokos notice. So it might, you might be hurting their ego, but you should not be concerned with their ego. You should just focus on the thing which is right and legal, because when they will be taking decisions on you, they will not be emotional enough. Now, there are, apart from, when we talk about contents and everything, there are two more judgments in this regard. The first one is metal forging versus Union of India by Supreme Court, in which it said that letters either in form of suggestion or advice or deemed notice cannot taken note as Shokos notice for the recovery of demand. Issuance of Shokos notice in a particular format is mandatory requirement of law. So even if you get an intimation letter, you get any advice, you get any deemed notice, and these are not just enough. You are bound to get, or you have a right to get that Shokos notice in a particular format which is mandated, and it is a mandatory requirement of law. Then that particular document will be considered Shokos notice. It is not that XYZ document just came to you it, and it is stating that this much of demand is due from you and you just pay the demand. It's not that, it's not like that. That Shokos notice must be in a proper format. The law requires the said notice to be issued under a specific provision of law and not as a correspondence or a part of an order. Obviously, notice whenever you receive any notice, so we'll be discussing in this detail as well that how you draft the reply of Shokos notice. But whenever you receive any notice, you must be seeing, or you must have observed in be it like in income tax or GST, that there is a relevant section under which that notice issuance was required as per the law. It is mandatorily to be mentioned on the Shokos notice as well, that yes, the Shokos notice is being issued under section 73, 74, or any penalty is being levied under that particular XYZ section. Apart from that, the said notice also will have to be served on assessee within a set period within 6 months or 5 years. Like, it is needed to be issued within a time frame which is given in the law. Therefore, it will be futile to contend that each and every communication or order could be construed as Shokos notice. So, we just cannot say that every notice or every intimation can be Shokos notice. But before coming to that conclusion that this particular document is a Shokos notice, you have to go to the, I would say, the key points which are relevant or which qualify it to be Shokos notice. Now, there is another judgment of Kaur Singh versus CC in New Delhi. It was held by Supreme Court that Shokos notice must communicate to the addressee the specific allegation or charge and the basis of for demand of tax. The party on whom Shokos notice is issued must be made aware of allegation against it, and that this is a requirement of natural justice. So this is what I've tried to say this. Now, after forms and content, we have come to know that everything is in order, it is bearing a din, and everything is fine. Now let's come to the point which is important, that this Shokos notice is issued within time or not. So there are two kind of limitation when we talk about in GST. Like, if you have short paid the tax, if you have availed the ITC wrongly, and if you have not paid the tax, then department have two options to recover that tax from you. One is under section 73, another one is section 74. Now, as I said, 73 is for bona fide people and 74 is for fraud people. Now, there are time limits. There is a difference of time limit as well. In section 73, there is a time limit of 2 years and 9 months. They do have this much of time for issuance of notice from the due date of filing of annual return for the financial year to which demand pertains, or from the date of erroneous refund. Now, you must be getting this idea when they have mentioned that from the due date of filing. They have not mentioned from any year. They have not connected to the any year. They have connected it to due date of annual return of filing. Now, you must be knowing that you just filed the 17-18 return in last year only. Now they have 3 years from last year. So for any fraud, or sorry, I would say any mistake you have done related to tax in 2017, so they ideally have 6 to 7 years to adjudicate that. So basically, now you understand that why they were extending the due dates of annual return, not waiving off the late fee on the due date. Obviously, they get the benefit as well from that extension of annual return. Now, notice issued after limitation is not sustainable. Obviously, if that time period of 2 years and 9 months is given in the law, and if you issue notice after that time period, it is bad in the law. The proper officer has no jurisdiction to initiate proceeding after the limitation period. The proper officer have no right to do that, and he have no jurisdiction to initiate any proceedings whenever that limitation period get done. It is important to note, when we talk about limitation period, it is very important to note there is a section 76 where the issue of Shokos notice, there is no time limit. And what is this section 76 is all about? When you collect the tax but do not pay to the government, then there is no limit for issuance of any Shokos notice. Now, when we talk about the fraud people, so there is a limitation period has a direct nexus with jurisdiction of authorities. There may be a difference of opinion on the reasons of proposed demand and applicability of section 74 and consequential higher limitation period. The terms fraud and any willful misstatement or suppression of facts to evade tax are very important and subject to different interpretation on different facts. So what does 73 and 74, uh, what are those words, what make these both of sections different is, first of all, when you apply 74, there might be some extra mind, you must be applying some extra mind, that why this person, you will have to prove that why this person is a fraud. Second, why this person should be given the punishment of section 74, that he has given any willful misstatement or he has suppressed any fact. But all these three factors are connected to a mindset which is to evade taxes. Now, whenever you do any fraud, whenever you do any willful misstatement, you provide any misstatement or any wrong document, and you have tried to suppress that fact as well, but your intention was to evade the taxes. Now the department will have to prove all these factors that yes, your intention was this. But in practical world, you see, they always try and go for 74. I would say the extended time limitation only. If we talk about the previous regime or in custom laws as well, they always try and they always go for the extended limitation period only. So this limitation period can be an important ground if you feel like that extended limitation period is not applicable to you. Since you have provided all the documents, you have not suppressed any facts, and you are not a fraud person, so what you did was correct as per you, and you can prove that fact as well. So then it is very important that you take this ground very seriously. Now, apart from that, if we talk about the word of suppression, which is specifically provided in explanation 2 of section 74, this is the only word suppression is being divided in the GST law. Other two words of fraud, or if we say the willful misstatement, are not given a definite definition in the GST law. Now, such type of provisions were present in erstwhile law as well. Obviously, there was a section 11 in Central Excise Act as well, and section 73 in service tax law as well. Therefore, judicial pronouncement under the act may be applicable if facts are identical. So there are a lot of judgments on these words when the department tried to implicate this extended limitation period and they failed to do so, or they even succeed to do so. So there are some judicial pronouncements in this regard. So there is a judgment of Messrs. Naresh Kumar versus Union of India, in which it was said that willful suppression cannot be assumed or presumed merely on failure to declare certain facts. Even if you don't declare any fact, that doesn't mean you willfully suppressing it, and it is preceded by deliberate non-disclosure to evade payment of tax. As I said, fraud, be it suppression, be it willful misstatement, all three factors are connected to the intention of evading the payment of tax. So that all these factors must correlate, then only you can apply this extended period of limitation. Now, so far as fraud and collusion are concerned, there is another judgment of Cosmic Die in which it was said that now, so far as fraud and collusion are concerned, it is evident the requisite intent, the intent to evade duty is built into these very words. So as I said, you have to connect these words with the main words of willful and suppression and the misstatement. Now, so far as the misstatement or suppression of facts are concerned, they are clearly qualified by the word willful, preceding the word misstatement or suppression of facts, which means with intent to evade duty. The next set of words, the contravention of any provision of the provision under this act or rule. Now, as you can see, I have not taken the literal definition of 73 and 74, but when you read the key section of these both of the sections, you'll get to know why these sections are different and why it becomes very crucial to differentiate and take the important step of making it a strong ground that yes, your case doesn't fall under the extended limitation period, or I would say that under section 74. So it is therefore not correct to say that these can be suppression or misstatement which is not willful, if it is a suppression which is not willful and yet constitute a permissible ground for purpose of proviso to section 11A. Misstatement or suppression of fact must be willful. Whenever you provide any document, suppose there are mistakes in it, and whenever you whenever they asked any information from you and you failed to do so and you have failed to provide so, so that doesn't mean that you have suppressed any fact or you have provided any misstatement unless they prove that it was a willful act by you. Now, there is another judgment as well of Anand Nishkwa Company Limited, in which it was said that we find that suppression of facts can have only one meaning, and that the correct information was not disclosed deliberately to evade payment of tax. When facts were known to both the parties, the omission by one to one what he might have done, not that he must have done, would not render it suppression. It is a settled law that mere failure to declare does not amount to willful suppression. There must be some positive act from the side of assessee to find willful suppression. So, whenever you are supposed to do something and you have not done it, and you had a reason for that as well, so that does not mean that it is a willful suppression. There might be reasons behind that. So what it is kind of a subjective thing, and you have to prove your thing that why this is not a suppression of fact. Now there is another concept before this hustle, before the initiation of this hustle, there is a concept which was in pre-GST regime. It was pre-Shokos notice consultation. Now, what is it? There is a pre-Shokos notice consultation with the assessee prior to issuance of Shokos notice in case of demand of duty which is more than 50 lakhs, except for preventive or offences related SCNs. It is mandatory and shall be done by the Shokos notice issuing authority. Whenever any proper officer in pre-GST regime I'm talking about, whenever any officer think that your case is involving duty of more than 50 lakhs, and before issuing a Shokos notice to you, if you have done something wrong, they will give you a chance of pre-Shokos notice consultation. So you can, they'll call you for the information, and you will make them understand that yes, I've not done this. These are my accounts. You prove them that yes, I've not done this fraud, or I have. These are the trail of transactions, and this is how I have paid my due taxes. So this is not what I have done wrongly. So this is something which they introduced just to reduce the litigation, or I would say the payload on the shoulders of officials, because they were like quite flooded with a lot of notices and a lot of adjudications were going on, some at the level of appellate authority, some might be at the level of tribunals. So they just wanted to keep that load little bit less. So that's why they introduced this concept of pre-Shokos notice consultation, though there are many officers and I would say many instances where we have seen that Shokos notice is being issued without a pre-consultation as well. So there are few judgments, be it like in Amadeus India of Delhi High Court, or Hitachi Power in Madras High Court, wherein court have quashed the Shokos notice and have said that you need to do that pre-consultation thing. Now the important thing, and I would say the important practical problem which we see in this problem is, if you challenge the whole thing before the High Court does not give you the relief from not issuing the Shokos notice. Only one step of pre-Shokos notice consultation would be added to that. Since it's a practical thing, but you are not avoided from doing something which you are, I would say, the legally bound to do it or something like that. But this is kind of a measure which they try to do it, and obviously there are many litigations as well in which this ground is being taken that I'm not given a proper opportunity of pre-consultation, and that's why this Shokos notice is needed to be quashed. So what practically happen is, the Shokos notice get quashed, obviously, and then there is a pre-Shokos notice, and then again that Shokos notice is being issued to you. So obviously there is an extra step which is being involved in this. But overall idea behind this challenging, be it like challenging the Shokos notice if the pre-consultation was not there, or the idea of pre-consultation is just to reduce the litigation and just to reduce that tussle between both the parties of taxpayers and officers. Now, and it becomes very important that whatsoever written in the law, and if department official is not going to challenge that mechanism or I would say the wrongdoing of officials, because they also do the same. So it's a two-way thing. Judiciary is equal for both the parties. So whenever any wrongdoings on either of the part, you can take the decision and take things forward. Apart from that, there is a pre-Shokos notice consultation in the GST as well. It's a kind of a like concept which is given in the rule 142 of CGST rules, sub rule 1A, which says that there would be a kind of a pre-notice consultation, that whenever any notice will be issued to any person, DRC 01 is being issued to anyone before raising any demand against him. So there will be a concept of DRC 01A as on there. Whenever any decision is being taken under section 73 or 74. So whenever any decision is being taken under section 73 or 74. So it's kind of a similar arrangement which they have tried to include. Now there is a concept which is related to when that any Shokos notice can be issued on legal representative, or I would say when any taxable person dies and Shokos notice can be issued upon legal representative. So there is a legal provision and there is a Supreme Court judgment as well in this regard. So what is the legal provision in GST? As per section 93, it says that law bounds to legal heir and legal representative or successor of deceased person to discharge the liability of tax, interest, or penalty out of the state of deceased person, whatever has been determined before his death but has remained unpaid or determined after his death. Now, there might be determination of payment of tax before his death or maybe after his death, but the department can recover only the tax which is out of his estate of deceased person. They cannot go to the legal heir to pay the taxes, or legal representative to pay the taxes out of their property. So it will be the property of only deceased person which will be used to pay out the tax, which whatsoever applicable on that person. There is a Supreme Court judgment as well, and it was said that the issue in the case was whether a Shokos notice under the Central Excise and Salt Tax 1944 could be issued to the legal heirs of sole proprietor after his death, against whom a Shokos notice had been issued raising a demand of Central Excise. The Supreme Court agreed with the appellant in this judgment, and they said that in above mentioned case that there is no machinery provision which is provided in Central Excise Act which enable the continuation of such proceedings against the legal heirs of the deceased assessee. So you cannot issue a notice to legal representative, or I would say any legal heir left behind after the death of the person or taxable person, but you can recover the tax. There is a machinery provision regarding the recovery of tax from the deceased person, but there is no provision in which it will be said that yes, you can very well take you can issue the notice upon the assessee as legal heir. And there is another judgment of Shokos notice, which is there is a question that Shokos notice can be based upon assumption or presumptions. That is also not true. Since it was decided in Oz Sugar Mills Limited, it was said that the Supreme Court pointed out that inference drawn by the authorities only on the basis of entries in ledgers would be insufficient. It was pointed out that in the factory where the turnover was considerable and the operations conducted involved a human element in a significant way, it would not be right to base the conclusions only on the summaries whatsoever provided by that. So the thing is, the department just took few of the documents from your premise. Suppose they have conducted any inspection and they have taken out some important documents from your premise, and later on you came to know that they have formed a belief or opinion and issued a Shokos notice on the basis of those ledgers whatsoever they taken with them. So the court said that it is very unfortunate and it is very I would say insufficient cause to issue Shokos notice, since you cannot take your mindset with I would say the assumptions or presumptions in your mindset to issue any Shokos notice. Now the important thing is, can there be any mistakes in Shokos notice? Suppose sometimes you receive a Shokos notice and something is not I would say something is not given correct in that Shokos notice. So can that be corrected, and how it will be corrected from the department side? So the important questions which were answered through two tribunal judgments which I have mentioned. In One important question survives for consideration, and the same is whether the legal mistake committed by the department can be corrected to ensure that offender does not accept punishment under a central excise law. So, court said that tribunal said that there is a clear distinction between the mistake of fact and mistake of law. The former one cannot be rectified at a later stage, but the latter is rectifiable subject to the course to the legal constraints. So if there is a mistake of fact, then the department can issue you a corriendum as well, or I would say a correct Shokos notice to you, a revised Shokos notice to you. But if there is a mistake of law, then there can be legal constraints, since that the recipient can also challenge that Shokos notice before High Court, and then you will have to prove that this was a mistake of law which they committed in a bona fide belief. So that is something you can also use whenever you respond, or whenever we try to respond to Shokos notices, that if there is any mistake in that particular Shokos notice, then you can see that Shokos notice mistake is a fact or law. And when we talk about the fact and law, that needs a very clear jurisprudences and behind these words, and there were a lot of judgments which decided only on the fact that this particular thing is a fact, or this particular issue is a matter of law. So that is also very difficult to deal with. Now, one important I would say legal principle is one who allege must prove establish. So whenever any Shokos notice is being issued, whenever any these notices must be containing all the points and all the allegations. So it is the duty of department to prove all those allegations. It is not the duty of assessee to prove those allegations, but they have formed their belief. They are with their mindset that they have interpreted their law, and they have done their homework with the way that yes, this person have not complied with the law. Now, there was a judgment as well of Lord Cholo Akali versus Special Director Enforce, in which it was said that it is a legal principle that the burden of proof is upon who affirms, not on him who denies. So if you're denying something and someone is saying that yes, you have done this mistake, so the burden of proof will be upon him who is saying that yes, you have done this. So this is your legal right to get that document that on which that particular belief was made upon. So the same view have been taken in other Supreme Court judgments as well, in which court have taken the same view that whomsoever the person is saying that yes, you have done this mistake, must be proving his point. Now, all this hustle, and I would say all these hustle, like from the analyzing the contents, or I would say the format, or if the Shokos notice is correct, and it is passing all the points which have mentioned by the various Supreme Courts. So there might be some other points, or there might be some other I would say circumstances in which Shokos notice is being not issued, but you are served with or you there is suppose there is inspection on your business premise, and officers comes to your business premise, and they see some books and documents, and on the basis of those documents they will be forming some Shokos notice later on. Now what you can do is, this is a legal right, I would say, that if any, after a certain period which is being mentioned in the law, suppose it's a 6 months, and they have not given you any Shokos notice within that period of time, then you have a right to ask that documents. Now those documents are also further divided up into relied upon documents and non-relied upon documents. So it's duty of department to give the non-relied upon documents within a due time, but obviously there is some extra time for relied upon documents to return if no Shokos notice is being issued. So whenever any inspection is there and department takes away your books of accounts, there is a set procedure to take it back. Since they do not have right, or I would say do not have right of lien over those documents, they can very well rely upon those documents and make use of those documents. But they cannot keep it for infinite period. So you must challenge that seizure as well if they do so, and if they are not giving you Shokos notice. Now, there is a Delhi High Court judgment in Vikas Kumbar versus Commissioner of Custom. It was observed that departmental authorities are under obligation to release such documents as are not relied upon by them within a reasonable time. Same decision was taken in a Salvi Paper Mills Limited. It was observed that considering the fact that appellant were not supplied with the unrelied upon documents, in that situation the adjudicating authority is directed to supply the remaining documents which were seized and not relied upon them appellant. Now this practice is sometimes done by the officers. I would say sometimes they want to pressurize, or they wishes to pressurize the fraud assessees, or I would say the assessees who have committed some frauds, or with the intent to evade the duty of tax. Then they do these kind of activities, and then they conduct some raids, or I would say search, and they seize the documents, then they don't give it back. But it's a legal principle which is cited in many judgments, which I just quoted, that if a relied upon document is not given, it's fine, since in that also there is a time limit of issuance of notice. If no Shokos notice is being issued to you and still those documents are not given back to you, you can challenge it. Apart from that, department is mandatorily required to give it back the non-relied upon documents within the time. So that's how this concept of Shokos notice is being conceptualized. And if any doubts you might be having, that whatever content must be in Shokos notice, and how we can read it, and how it will be helping us to draft the notice, and how it will be done, like how should we see a Shokos notice, since it's, in my humble opinion, it's very important to I would say reply to all these Shokos notice with utmost care, as much as we can, since in GST everything is very gloomy. Every provisions is being challenged before the high court. So at this time, when I would say the ITC is also being said that it's not our vested rights, then you can understand that how they have complicated this law for everyone. And apart from that, when you submit that document, or whenever any summon is being issued to you, or any they want to record your statement, so they call for you. So there is a very common questions which is being asked, and which I have seen in practical life as well, that when they ask to the client, or when they issue any summons, so can the counsel, or I would say CA, can be present at the time of recording of statement. So court is very clear in this. Obviously, when summon is being issued, it's a proceeding as per CPC, sorry, and then that particular person cannot be there. And it is being cited in MK Kundia versus Union of India, in which Supreme Court said that whenever any interrogation was conducted under Section 108 of Customs Act, the counsel cannot be present. And if he want to present, he will be at distance, that he cannot hear anything, but he can see everything. So he will not be in a hearing range, but he will be in a visible range. So as per the law, a CA or advocate cannot be present at the time when any interrogation is being conducted with the client. Now, next part of summon, and how will you be responding to these notices will be taken by Archana ji.
Thank you, Navjot. Thank you for this wonderful presentation on this show cause aspect, notices, show cause, or any communication that we are receiving from the department. And before I initiate this second part of our presentation, I think there are a few queries regarding the first portion. Can we just quickly take up so that even they'll get a break of 5 minutes?
Yeah.
So, okay, the queries, if I start, are we bound to respond the notice issued without DIN? we can always raise this issue that yes, DIN was not mentioned over that notice or that communication. So we should not call it a notice, first of all. There is a differentiation between the notice and the communication that we are receiving from the department. Yes, there has been a mandate that any kind of communication should be bearing a DIN, and that has been properly notified also. So whenever we are receiving any kind of communication, whether through email or through speed post or by whatever mean we can say, there has to be a mention of DIN. So in case this DIN is missing, then we can always reply to that notice and we can say that the DIN was not DIN was not appearing on the said communication. So we would like to have this communication in a proper format, so that at least, because see, DIN is not that big issue. Even if you say that DIN was not mentioned on that document, that's why we didn't comply with that. Okay, taking into the cognizance what our honorable finance minister has said, but still we can always communicate the same to them that yes, DIN was not there, and so we are not responding anything as of now. So kindly issue a proper communication with proper DIN number. Anything else you want to say on in this aspect, Navjot?
Yeah, ma'am, I agree to that. Apart from that, Nimish Kumarji have asked that are we bound to respond the notice without DIN? No, we are not bound to do that. But in practical way, I would suggest you to keep in the touch with officer, since just on this issue, if you just want to challenge it, you very well can. But I think that wouldn't save you from the whole adjudication proceedings. Now, apart from that, Hardeep Singh ji have said that as per section 7512, there can be direct recovery of interest without Shokos notice. And Hardeep ji, I would say one thing, that obviously there can be a statutory obligation or anything can be written in the law, but it cannot supersede our constitutional rights. So if something is a natural justice is being given, and there are many instances, or I would suggest a lot of judgments wherein it is being said several times by Supreme Court that Shokos notice is very necessary, be it like any law. I am not talking about the taxation law. Even if you see the ED proceedings or even see the criminal proceedings, then also Shokos notice is being given. So, and second thing, I would say that whenever we try to read the judgments in which writs are being filed, see, in writs there can be facts, there can be legal discussions as well, but there are certain facts as well. So there might be two different decisions by two different high courts on the same matter. Like suppose example is being given like VKC footwear, in which like input services were entitled for inverted duty refund, but the Madras High Court did not give the same judgment. So that's how the writs are. That's how the legal remedy is being exercised, and your facts might be different. And when you drafted that writ, on what ground you went in the High Court, for challenging those provisions. So that differs. But yes, from department side, yes, if we do the plain, if we read the plain law, yes, we do not have any Shokos right whenever they try to recover the interest from us.
But
But
Hardeep ji, you have to understand one more important thing in this line is that 7512, if you see, it says that duty remain unpaid by virtue of section 39 return. Apparently speaking, I don't think so they have any mechanism, because we cannot file a partly paid 3B. Whatever disclosure you have made in your 3B, that has to be fully executed, that has to be fully discharged, then only you are able to file the return. Otherwise, you are not able to file the return. So technically,
exactly.
the provision does not stand correct as of date, but yes, they have the provision.
Right. And he have asked some, we'll just take the last query and then you can move forward. He's saying that state government authority is not legally bound to issue DIN. Yes, they are not, and they are not even doing that, since it was a circular by CBIC. And if we want to discuss that now, the tussle between the cross empowerment and everything, what they have said in the council meetings, that there will never be any cross empowerment and one nation one tax, and all these theories get somehow fails when the state officials say that these circulars of CBIC doesn't applicable to us. So that's a different issue, sir. Ma'am, I think you
Yeah.
can take forward and we can take all these queries in the last.
Yeah. So, okay, so we'll start with the second aspect of summon. So we all know summon means a kind of intimation which is required to be served to any person which a department or any other deems that yes, this person has some kind of information that is required for his adjudication or whatever matter it is in his hand, or whatever inquiry he has initiated. So these are the provisions. And someone can, again, if we see that yes, the power to summon has been mentioned in direct tax as well as indirect tax. Indirect tax under section 131, and indirect tax, if I talk about the in erstwhile regime, it was section 14 under center excise, under section 70 under GST, and section 108 under Customs Act. And these are the things that there have been certain parallels to the other CPC also, where they have said, okay, whatever the proceeding that will be initiated through these summons will be treated as, or they will be treated or termed as judicial proceeding, and those also as per section 193 and 228 of IPC 1860. But the power was somewhat diluted in because there was no mention of the situation that what will be taken or how it has to be done in case the taxpayer fails to appear before the summoning authority, even after giving a reasonable opportunity, or even by serving the summons for the repeated times also. But still there may be some kind of lacuna, or there may be some kind of what we should say dilution from the taxpayer side also. So these situations were not taken care of. But yes, with due course of time, these situations, as they have felt that yes, they were making the whole procedure cumbersome, the intent of the whole procedure was being diluted because of these deficiencies in the section. So what they have done is that yes, they have ordered that the civil code, because there was a certain procedure laid out that yes, in such cases they have to follow the procedure, they have to go to the civil court, and then they have to make that either they will issue a summon that they will again issue they have to invoke section 172, 173, 174, 175 of IPC, and accordingly taxpayer will be summoned again for the non-appearance. So again, it was a time-consuming process, because once you have to reach to the court, then we all know that there is a limit, there is a delay in all the proceedings that has been reaching the judicial courts because of the long pendency. So that thing has been taken care in direct tax. So they have amended, and now we have seen that yes, now there is some other aspect, and under section 70 also they have taken care that okay, whenever they will be issuing the summons, so it will be taken as a judicial proceeding, and whatever things they have said that okay, it will be taking its meaning from section 193 and 228 of the judicial IPC code, and non-appearance will be treated as a non-compliance, and there is a penal provision also under GST. So if we see this section 70, where the power to issue a summon has been given under section 70 of the CGST Act, it is very, very small section. Only 2 paragraphs are there. And if I read from the Bare Act itself, what exactly the wordings of this summon is, so power to summon, section 70, the proper officer under this act shall have the power to summon any person whose attendance he considers necessary. So thing is any person. So here the word is any person, not a taxable person, not a registered person, but any person whose attendance he considered necessary, either to give evidence or to produce a document or any other thing in any inquiry in the same manner as provided in the case of a civil court under the provision of Code of Civil Procedures 1908 CPC. Every such inquiry referred in subsection 1 that we have just read shall be deemed to be a judicial proceeding within the meaning of section 193 and section 228 of the IPC. So this is the complete section as it has been written in your Bare Act. So what we say is that a person, a proper officer, he has the power to summon any person. So he need not be a taxable person, he need not be a registered person. And now with the new amendment that we have seen in section 151, now they have again elaborated their power. Now they can summon any person whosoever they think that okay, he may have some kind of data pertaining to this particular assessee, or he may have some kind of data that may be required for the ongoing inquiry that they are already ongoing, they are already initiated, or they are already into some inquiry or investigation. So even a third party can be summoned, even the professionals can be summoned in these regards. So the wording of this section has been really, really open-ended, and they have really given immense power. And we have seen in other procedures or in other laws, we have seen that someone should be the last resort when you think, okay, the person is non-complying to the repeated intimation or the repeated communication from the department, then he should be summoned. But under GST, what we are saying is that On the initial stages only, you will receive a summon that, okay, the person has been summoned, you are required to appear in my office on so and so date and so time. And because why? Because your appearance is required for to tender the statement or to provide the documents, and then there will be a list of documents annexure annexed to that, and you have to appear with all those related documents, all those related information, and there will be a stipulated time period also. So we have seen that under GST, this section has been used to, what we should say, to inquire, to collect the information, to even collect the information that may be further used against the assessee only. Section 2, subsection 91, because the word over there has been proper officer. So who is a proper officer? So that has been decided, that has been prescribed under section 291. Proper officer in relation to any function to be performed under this act means commissioner or the officer to the central taxes who is assigned that function by the commissioner in the board. Section 3, 4, 5, 6, we'll see they have the cross empowerment also, and there they have completely prescribed and described that who can be a proper officer. Then there was a circular 3 oblique 2017 where they have prescribed and described that who can be a proper officer in respective matters. And again, that has been revised by circular number 31 oblique 5 oblique 18 dated 9th of February 2018. So there you can always check. So first thing, whenever you are receiving a summon, you should see whether that has been issued by the proper officer as per the circulars that has been issued by the department, that these are the officers or these are the proper officers who has been empowered to issue the summon. So whether that summon has been issued by that proper officer or no. So we have to see whether that summon is defective or not. Then judicial proceeding, what does it mean? Any inquiry referred to in section 70 subsection 1 of the act shall deem to be a judicial proceeding, we have seen, within the meaning of 193 and 228 of IPC. 193 relates with the punishment for the false evidence. In case you are giving any kind of false evidence, then yes, as per section 193 there is a punishment which may start from 0, that may range from 0 to 7 years, and a fine also. And so they have a prescribed penalty. So this is first time they have said, okay, now the penalty is also there. Then is 228 of IPC, which says intentional insult or interruption to public servant sitting in the intentionally offers an insult or cause any interruption to any public servant while the public servant is sitting in any stage of judicial proceeding shall be punished with an imprisonment of 0 to 6 months or fine up to rupees 1000 rupees or both. So in both the scenarios, the punishment has been prescribed for the non-compliance of the provisions under 193 and 228 of IPC. Now there is a safeguard also. We have seen that whenever you are receiving a summon, there are two aspects. Either that is for the submission or some kind of documents has been asked by you, or tender of statement. And we all know, and there are plethora of judgments on these aspects now. There has been clarifications, and even in our first part, we have seen that yes, who can be accompanying the person? Can the authorized representative be a person who can tender the statement on his behalf, or only that person on whose name the summon has been issued will be able to tender the statement? So 136 of CGST Act is drafted in a way to safeguard the assessee, to safeguard the bona fide taxpayer. So they says that, okay, whatever the statement has been tendered, so that cannot be used as it is, or there are certain circumstances under which only that can be used as it is. Otherwise, there has to be a proper procedure to be followed before that statement or before that evidence, or whatever the statement or whatever the evidence that has been awarded during that tender of statement can be utilized as it is. So 136 has two parts, 136A and 136B. What does it say? The statement made and signed by a person on appearance in response to any summon issued under section 70 during the course of any inquiry or proceeding under this act shall be relevant for the purpose of proving in any prosecution for an offense under this act the truth of the fact which it contains, a part, when the person who made the statement is dead or cannot be found or incapable of giving evidence or kept out of way by the adverse party, or whose presence cannot be obtained without an amount of delay or expense, which under the circumstances of the case the court considers
I think there is some technical error on our side. I'll take things forward for a while. That there are some CBIC FAQs as well in relation to someone when we talk about someone. So there are certain responsibility of the person so summoned. Now, a person who is summoned legally bound to attend either in person or by authorized representative, and he is bound to state the truth before the officer who has issued the summon upon any subject which is the subject matter of examination, and to produce such documents and other things as may be required. So this is what they have given in their FAQs. Now, what are the consequences of non-appearance to summon? This is also an extract from the FAQs only, which they have given. Now, the proceedings before the official who have issued a summon is deemed to be a judicial proceeding. Now, if a person does not appear on the date when summoned without any reasonable justification, he can be prosecuted under Section 174 of IPC. If he absconds to avoid service of summon, he can be prosecuted under Section 172 of IPC. And in case he does not produce the documents or electronic records required to be produced, he can be prosecuted under Section 175 of IPC. So when we talk about the summon, it even becomes very important than the replying to Shokos notice as well. Since it's in Shokos notice, at least you'll get only the order in original, which might be in adverse nature. But in summon, if you don't do it, then there might be some other implications of Indian Penal Act, Indian Penal Code. Yeah, ma'am. I've taken this slide. You can take from this one. This one, yes.
Thank you. And I'm so sorry because of this load shedding. At times, I mean, you have to bear this. So there is a lag time between the switching over to one system to another system. Okay, so I'll carry it further. So guidelines has been issued for the issuance of summon by CBIC also, and they says that okay, the CBIC in the Department of Revenue, they have issued as a last resort. They themselves have said that it should be issued as a last resort, that where the assessee is not cooperating, or where they think that okay, the involvement of the top management is required, then only they should be issuing the summon to the top management, or the summons, at least summon should be used as a last resort. But we are saying that it is not being followed under GST at all. The language should not be harsh, and we have seen that at times we have come across the summons which says that you are not supposed to leave the office without my permission or before you are being asked to. So how can you issue such kind of summon that where you have asked a person to sit in his office for 8 hours, 10 hours, and I mean he cannot leave your office without your permission? So these are the things that should not be there in the summons, but we have seen that everything and anything is happening under GST. Summons by superintendent should be issued after obtaining a prior written permission from an officer not below the rank of an assistant commissioner, with the reason for issuance of summons to be recorded in writing. But I mean, we cannot see whether the same procedure has been followed or not. Where for operational reason it is not possible to obtain a prior written permission, oral or telephonic permission from such officer must be obtained, and the same should be reduced to writing and intimated to the officer according such permission at the earliest opportunity. So we all know how these provisions are being made and how these provisions are being used. In all cases, where summon is issued, the officer issuing summon should submit a report or should record a brief of the proceeding in case, file and submit the same to the officer who had authorized the issuance of summon. So everything has to be in writing. We have seen there is a note sheet whenever you are appearing for any kind of hearing where you have been summoned. So they are writing, and you are bound to sign on the note sheet also. And at times, whatever you may be asking them to write, when they are interpreting in their own words, so there may be some kind of difference. So our suggestion is, whenever you are attending any kind of statement, whenever you are giving any kind of information to the officer, kindly recheck whatever that has been reproduced before you has been correctly reproduced as per your wordings or as per your intent or no. In case you find that yes, there is some kind of discrepancy, you are always allowed and you are eligible to request them to kindly make the amendments. And in case that same is not being made, even you can make a note of that same while you are signing, that yes, these was my wordings, or this was the intent by which I have said these words. And in case you are not able to understand, in case you are not having that particular information that has been asked to you during that investigation or interrogation, you can always say that, okay, I'll check out my facts, or I'll get back to you on this matter. So there is not hard and fast foundation that you have to answer each and every question. But yes, in case you have the information, then kindly provide the correct and true information while you are tendering the statement. Senior management officials such as CEO, CFO, or general managers of the large companies or PSU should not generally be issued summons, but largely, and by what I have seen or what I have come across, is that we have seen most of the time these summons are issued in the name of director or CFO. And even for the petty issues, like I have handled one case where only the total amount of tax, including the penalty and the interest, was amounting somewhere around 8,469. And for that also, they have summoned the director. That too is sitting in the in the jurisdiction of Bangalore, that you have to come, you have to personally appear in my office, because these are the things, or these are the ITC which I'm not allowing, and this is the amount that is liable to be paid. So we have discharged the everything, whatever the demand has been issued. But I mean, I'm just giving that for such a meager amount also, they are issuing summons directly to the directors. Precaution to be observed, so we can go through these quickly, because these are the things that has been issued with respect to the department. That someone should not be issued for appearing while it is not justified. The power to summon can be exercised only when there is an inquiry being undertaken and the attendance of the person is considered necessary. Normally, someone should not be issued repeatedly, but we have seen summon 1, summon 2, summon 3. Respect the time of appearance given in summon. No person should be made for waiting for long hours, and ironically, this is never being abided by what I have seen. Preferably, statement should be recorded during the office hours. However, an exception could be made regarding the time and place of the recording of the statement, having regard to the facts of the cases. Okay, so now we have seen that, okay, we have received that summon, or we have received notice, or we have received some kind of intimation from the department, or any kind of communication, whether they are initiated some kind of inquiry or initiated some kind of investigation, or there is a third party investigation, or you are the third limb or the fourth limb and they want some kind of data from you. So any kind of communication that you have received, so there is no need to panic. How we have to deal, that we will be taking up in the coming slides. But first and foremost thing is that, please, please, please don't ignore. Yes, there may be some kind of deficiency, like dead number is missing, or at times you have to see that proper whether that has been properly scanned, because nowadays even we are receiving the Shokos notices via WhatsApp also, via emails also. So you have to see whether that has been prescribed form of serving of that notice or communication or not. And in case that has been not properly served, then we can always challenge the aspect also. So first of all, we have to see that, okay, whenever you have received some kind of notice or summon, then what you have to do, how you have to deal with the same. Very first thing is, you have to see, you can challenge any show cause notice, but there are certain restrictions on the initial stage. In case of these things are present in that show cause notice, then only prescribed things has to be dealt with. Then only you are able to challenge the same at the High Court. Otherwise, the first and foremost question that will be asked to you in the High Court is that whether you have taken care of the normal proceeding or alternate remedies or no. So we have to see whether that show cause notice has been issued with a predetermined mind. Whether, I mean, you can understand, whenever you read that show cause notice, whether he has taken care of all the facts, whether he has taken care of all the evidence that you have produced before him or not, or he has just relied upon whatever assumption and presumption he had in his mind and he had issued that show cause notice. In case this is the case, you can always challenge the show cause notice by filing a writ under section 226 in the High Court. Second is whether the show cause notice has been issued by violating the principles of natural justice. That means your opportunity was not given to you, proper due course procedure that has been prescribed were not followed. And in simple case, we can also say that yes, in case there is a pre-consultation provision, but whether that has been followed or not followed, there are certain judgments on the same ground, or even at times we have seen the assessee himself has settled case in the prior period or at the higher level of authorities, and still that show cause notice has been issued on the similar grounds. So these are the things where we can see that, okay, there is a violation of the principle of natural justice. We can challenge that show cause. Abuse of the process of law, obviously. misuse of the power or abuse of the process of law. Lack of jurisdiction. You have to see whether the person who is issuing that show cause notice, whether he has the jurisdiction to do so or no. In case he lacks the jurisdiction, then also the same can be challenged and can be dropped also by the Honorable High Court. Question of limitation. Again, time period has been prescribed, so you have to see whether the show cause notice is time barred or no. So all these are the aspects where you can easily challenge the show cause notice by way of a writ petition. So there are certain favorable stand in this regard, and like in Vico Laboratories, they have said that normally the writ should not interfere at the stage of issuance of show cause notice by the authorities. In such a case, the parties get ample opportunity to put forth their contention before the authorities concerned and satisfy the authorities concerned about the absence if the case of proceeding against the person against whom the show cause notice has been issued. However, the said rule is not without any exception. Where a show cause notice is issued either without a jurisdiction or abuse of the process of law, certainly in that case, the writ petition should not be hesitated to interfere, even at the case of show cause notice. So we have seen. So these are the things that we have to see whether these ingredients are present or not. And in case you have any kind of these ingredient in your show cause notice, then you very well have this remedy of filing a writ petition on the High Court. Similarly, Oxy-Fisheries case is also there, which says that show cause notice cannot read hyper technically, and it is a well settled that it is to be read reasonably. But while reading a show cause notice, the person who is subject, it must get the impression that he will get an effective opportunity to rebut the allegation contained in the show cause notice and prove his innocence. If on a reasonable reading of a show cause notice, a person of ordinary prudence gets the feeling that his reply to the show cause notice will be an empty ceremony and he will be merely knock his head against the impenetrable wall of prejudiced opinion, such show cause notice does not commence a fair procedure, especially when it is issued in a quasi-judicial proceeding under a statutory regulation which promised to give the person proceeded against a reasonable opportunity to defense. That means he is issuing the show cause notice with a preconceived notion or with a predetermined mind, and in that language only he has issued the show cause notice. The same can be easily challenged. In TRF Limited, it was held neither the issuing authority nor the assessee should make a prestige issue. It is especially so as quasi-judicial proceedings are initiated by the officer exercising vast statutory power and jurisdiction, which should not be misunderstood to have been exercised to humiliate a person holding the position in assessee company. The reason for forming opinion against assessee as required to be reflected in the notice itself, it cannot render notice illegal as being issued with a predetermined mind. However, notice reflecting in unequivocal equivocal terms decision on contentious issues rather than pulling question to the assessee may something reflect the predetermined mind of the issuing authority. Again, on the predetermined mind only. So again, these are the remedies that are available in case we see that yes, the issue has been already in their mind and they are not going to listen to your replies, or they are not going to consider whatever evidentiary document you provide to them, what are kind of replies you are supplying to them. They're not going to consider and they are going to issue the order only with their preconceived notion. Then again, you have the right to challenge that show cause notice. High Court can interfere again where there is a violation of the principle of natural justice that we have already seen, and that has been settled in the case of Naresh Kumar and company also. The challenge is on the ground that condition precedent to the exercise of jurisdiction. It is a question of jurisdiction. So again, when there is a lack of jurisdiction or the limitation is with respect to the jurisdiction, again we have seen that yes, you can go and knock the door of High Court to quash that show cause notice. There are contrary stands also. Not every case is not settled in the favor of assessee. So there are contrary stands also, which says the exercise of law is a complete code in itself, and it would normally not be appropriate to file a writ court to entertain a petition under Article 226 of the Constitution, and that the concerned person must first raise all the objection before the authority who has read. That means this is okay. First, you go and consume your alternate remedy in case you still feel that okay, the person has not taken care of your procedure, or he's not taking your care of the evidence that you are providing. Then only you should go to the court. Otherwise, not for the quashing of the show cause notice because of some kind of defects in that. In Maladi drugs, they have said that High Court has by the impact judgment held that the appellant should first raise all objection. Again, same on the same line, it has said that okay, first you have to take care of all the alternate remedies that are available to you before, and in case still an adverse order is being passed against you, then you have a liberty to go to the court. State of UP High Court held that jurisdiction of High Court under Article 226 of the Constitution should not be permitted to be invoked in order to challenge a show cause notice unless, accepting the facts stated therein be correct, the show cause notice is ex face without jurisdiction. That means apparent on the face of the SCN, it should be apparently appearing that yes, it is exceeding the jurisdiction or it is without the jurisdiction. Then only it will be entertaining. Otherwise, it will not be entertaining. So what all you have to do after you have received the show cause notice? Okay, so first of all, it is very important to note down the date of the receipt, if possible. If in case you have received a hard copy, then you should keep the envelope and everything intact for your future reference, so that it can be proved that there may be a case that order may be signed, let's say on some other date, and it has been served to you on some other date, and recently there was a judgment. In case some order has been signed and kept in drawer, and after a few months it has been served, so it will not be treated as that it has been served, because there is a proper timeline. It should not be that after 6 months or 9 months you are serving that order to someone, or serving that show cause to someone. So you have to be very, very minutely taking care of all these details. So date of receipt has to be taken care of. Then you have to see what is the time limit that has been prescribed to reply for that show cause notice. Usually we have seen that there is a 30 days time limit. So within that 30 days, either you should provide the reply, or you should seek for the extension. In case you see you feel that yes, there is a large amount of data, or whatever the reason there may be, you have a right to seek for the extension, but that has to be complied within the timeline, so that there should not be an ex parte order. Reading of a show cause notice is very, very important, and kindly my way of doing is that we make note of each and every paragraph, and each and every paragraph should be replied or dealt with in your reply. There should be a point wise reply to all the show cause notices that you are replying, so that the proper care for each and every issues that has been raised on the show cause notice can be noted down. Analysis of issue with client and collection of the pertinent detail. I always say that person should never speak lie in front of two persons. One is your counsel and other one is your doctor. Why I'm saying so? Because as a counsel, we are treating that particular issue as a doctor-patient relationship only. So whatever the facts are there, that should be correctly communicated to your counsel, to your consultant, whosoever is preparing the reply. And my honest suggestion is that we should not try to reply, because I have seen many a times that show cause notice are being very, very uh, badly they are being replied by the assessee, or not taken due course of time, or they have not taken due diligence while drafting the replies, and they have seen that the outcome may not be as good as you are expecting, or even at times the outcome may have been beyond what you have expected. So please do take care, because this reply, the initial reply of any kind of intimation or communication from the department, will be treated equivalent to what we say FIR. Even if that case will be taken, let's say, to the highest authority, to the apex court, still your replies will be the same, and they will be treated while deciding the case even in the apex court. So all your replies has to be really, really well drafted. They have to be taking care of each and every aspect that has been questioned in your show cause notice. Every point has to be dealt with properly. Whatever contention or whatever evidence you want to put forward should be taken care. You should not even lose the opportunity of any further submission that should be awarded to you. You should properly ask for the opportunity of being heard before that SCN should be decided. So all these things has to be taken care, and each and every issue that has been raised in that show cause notice should be properly analyzed and should be properly dealt with, and even the assessee should provide each and every detail pertaining to that issue. Then comes the drafting of the response. So date of receipt of the show cause notice plays a very, very vital role, because at times we have seen that show cause notices are being served on the very last day. So in case that has not been properly served on that last day, then it may become a time bar issue, and you may not even go into detail, and you may only say that you may even win your case on the time bar issue also. So it is very, very important that the documentation of the date of receipt of the notice is created without any fail. So in case you have an received through email, so kindly make a PDF format of that email and keep it on a safe place. Similarly, in case, as I have told, in case you have received physically, then you should keep intact all the documents. It is suggested that one page print of email or a photocopy of the postal copy should be preserved in the file. The calculation of 30 days from the date of communication of the notice and not from the date of signed on issuance of that show cause notice. Time limit, we all know section 73 and 74, they both have prescribed a time limit for the issuance of show cause notice as well as for the reply. And as in GST, we have seen that 30 days time limit has been prescribed, and they are giving each and every show cause notice will be at this 30 days time limit. So either you have to submit your reply or you have to apply for the extension. Reading show cause notice must be read line by line and in detail. We need to look for the detail which can give us the complete picture of the issue, right from the basic detail of the SSC, including the GSTN number, tax period, everything should be minutely taken care of. The issue, the transaction, the calculation, the amount involved, whether it is an interpretational issue or whether that has been well settled issue. So all these things has to be taken care of. This will enable us to get a good grip on the issue while we are going to draft the reply. Analysis of issue, obviously many details may come out when you have one-to-one discussion with your client. At times we may not be taking, we may be perceiving that that particular issue from one direction, but he may be able to give you the another direction or another side of that coin also. So there has to be a detailed communication, there has to be a detailed discussion on the issues that has been raised in the show cause notice. The client may sometimes come up with a new information also, which may be helpful information for you while you are drafting the reply. Or at times there may be a thing that, okay, they may have not taken or not considered some information that has been already provided by the SSC. So even that should be taken care of, and that should be incorporated while you are drafting the replies. Drafting of response is an art. I always say that it is an art. Purely it is an art. And the way you are drafting a reply, the way you are drafting a response, the way you are drafting a response to the Okay, so we were there. Again, I'm so sorry for this technical glitch. It requires a regular practice of reading the law and its daily update, along with the reference to the landmark judgment pronounced by various judicial fora. And if you are following our LinkedIn page, so you will be seeing that every new judgment is coming up, and we are giving our own interpretation, how that has to be read, how we have understood that particular judgment. So these kind of practice also help us in drafting a good reply. A good and tasty food, though presented well, will not be attractive unless it is presented well. So once you have you have all the facts, you know the case, you know the facts, you have the plethora of judgments in your favor, but still that has to be properly incorporated, drafted, and properly presented in a proper manner. Proper margin should be there, proper gap should be maintained, the reply should be in a para format, and the para should not be too lengthy. You should break your para. So these are minute things that has to be taken care. The things that you really need to highlight should be bold, italic, underlined, so that they should come out. Okay, this is what you want to tell, this is what you want to present. So all these things has to be really taken care of. Similarly, the presentation of response matters a lot when it comes to the responding to the show cause notice. Further, the environment for drafting of response should be calm and quiet without disturbance, because otherwise you will not be able to concentrate on all the points that need to be. And I have seen you, at least you should read your show cause notice 3 to 4 times. And every time you're reading, kindly make note of them. And you'll see that every time you're reading that show cause notice, new points are appearing in your mind, new line of action will be appearing in your mind. You will be seeing some other arguments on those points. You may be finding something else is being striking. Okay, it should be taken care in this manner. Okay, I have read this provision in some of the case laws that I was reading, and there the court has taken this stand. So all these things are going to make, or going to help or assist in drafting a good reply for that show cause notice. And I have seen once a notice has been properly replied, properly taken care of, so even the other side of the table, even the authorities have to work hard on deciding that matter, because straight away they cannot see. And I have seen the replies also. At times I have seen replies of a show cause notice which is running to 5 or 6 pages, and the reply is also running in 4 or 5 or 6 pages. Agreed, denied, denied. What denied? You have to give your uh, proper response to that. You cannot just say it is wrong and denied. Why it is wrong and denied? Why you are saying it is wrong and denied? What is the legal provision behind this wrong and denied? So everything has to become in detail in your reply, so that the other person who is reading that reply should understand. Okay, you have dealt it in a legal manner. You are aware of the provisions. You are aware of the facts. You are aware of the circulars or the notices that has been issued in that manner. So they cannot ignore, because circulars are binding on them, notifications are binding on them, and in case something is in your favor, then you should always quote them. So these are the way you can always make a good reply. The drafting of a reply to a show cause, okay, it is a duplication. The reply should be prepared by responding to each and every paragraph of the show cause notice, which is very important. So kindly don't ignore this point. The drafting should cover response to all the issues and allegation made in the notice. If any of the issue or allegation is not addressed, the proper officer may deem it as an acceptance. There we all know that non maybe, or non-speaking or silence may be treated as yes, or that you are accepting the same, and it will have a negative impact on the outcome of the adjudication process. The reply should be crisp and specific to the point, and it should not be like beating around the bush. You should not say, okay, this. No, don't make it circle. Make it on make according to the points. It has to be crisp, and you should be hitting hard on the point which you want to speak. Wherever required, the reference of the provision of law can be quoted and explained in detailed manner, which will convey the clear message and how we have interpreted the provision, why I have reached to this understanding, why I have reached to this conclusion. So there has to be some kind of legal backing for that. Issue involves interpretational penal provision cannot be invoked on taxpayers. Wherever there is an interpretational issue, the response should contain the structured method of interpreting each and every word, phrase, or line of the section. Even we have seen there are judgment on how to interpret the comma, how to interpret semicolon, how to deal with the words that are coming after a particular word. There are various interpretational rules like noscitur or Shokos or ejusdem generis, how that has to be dealt with and how they have to be applied. Further, wherever possible, the allegation made in this SCN should also be referred, and it should be brought to the notice of the adjudicating authority as to why the conclusion drawn in the show cause notice by the way of a wrong interpretation cannot be held valid in the eyes of GST law. And there are a lot of interpretational issues that we are seeing. Even 9610, that is the hottest topic that we have seen, we are seeing across, and every day new notices or new intimations are coming from DRI or DGGI on this particular aspect. Earlier we have seen the classification issue with respect to the hand sanitizers, and many people were summoned. Even automobile industry, tire industry. So there are industry specific issues also on which we have seen that lot of litigation is going on. Classification issue is again one of the important aspects, because there may be a uh, classificational issue which may either make your product fall under higher category, or whatever input you are taking may be falling under lower category. So both the aspect has to be taken care of, and who is taking care of, who is one who is involving that ITC, who is claiming that ITC, again he's also responsible for the correct classification and correct rate of taxes. I'm not going in detail with this because we have already dealt with this topic in detail. So you can always refer to our classification webinar where we have dealt in detail with all the aspect of HSN classification, how they have to be interpreted, how we have to go and find any classification, how the help of rules can be taken care of, what we have to do in case of any ambiguity is there. So all these topic has been dealt in our classification webinar. Calculation table, whenever it involves some kind of calculation, let's see, for a very common example is whenever there is a refund rejection order or SCN regarding to your erroneous refund, so where they have given some kind of calculation, so you have to again verify their calculation. In case there is some difference, or the methodology that has been adopted by the department is not correct as per your opinion, then you should be able to give a proper calculation with respect to what they have done and what should be the real correct calculation, how you have confirmed that particular amount, or how you have derived that particular amount. That calculation should always be there, or should be always be provided to the department. We should be able to defend the method and the calculation by highlighting what is missed or wrongly considered in the calculation adopted in the show cause notice. And this is really very, very important, because at times we have seen that there are minute errors because of which the amount may have derived to some other conclusion. So we have to be very, very clear how we have calculated, how the department has missed that particular thing, or how they have incorporated the wrong methodology or the wrong amount for taking that calculation into consideration. The reply should not be cluttered. So everything should not be dumped at one place. It should be properly detailed. Case laws should be there. Copies of whatever thing that you want to annex, they should be properly annexed. A proper index should be maintained. The list of enclosures or the list of annexures should be properly provided to them. It should be properly serially numbered. So everything should be presented in a presentable manner, so that whosoever is running through that reply is able to correlate, okay, what you are going to say to him, what you are going to present before him, and how that has to be dealt, and how the evidentiary document has to be seen, and from where they can be correlated. So these things has to be very minutely taken care of. This will help the reader of response to develop a positive feel and understand the issue in a better manner, or also refer to the annexures wherever necessary. The reply to show cause notice shall be provided with OTC along with the annexures on white sheet of size A4 or legal as per the requirement. In total, 3 sets of the response should be prepared: one for the submission of the department, second copy should be obtained along with the acknowledgement, and third one as client copy, which also will come handy in time of need. The response shall be printed with page numbers on every page, including annexures. The paper shall be neatly assembled and tagged properly before submitting. And that should be, if possible, that should be properly filed, or that should be properly spiral binded, or something of that sort, so that the paper are not loose, or you should not hand over the thing in such a manner that it is cumbersome to handle the thing, or you may lose some of the papers while submitting the uh, submission to the department. So then there are certain key terms when you are preparing for the replies, which has been referred, or you must have heard them many a times, like law of precedent, what has been decided, so that can be followed. So doctrine of judicial precedent or judicial discipline and res judicata has been evolved to ensure stability and certainty in law. That means one aspect which has been decided should be followed. And we have seen that until unless there is a major change in the facts, so once a case has been decided, so normally the same court will not decide the same fact, same kind of case in some other manner. So Honorable Supreme Court in the case of Union of India and Kamalakshi Finance Corporation has reported and have said that adjudicating officer act as a quasi-judicial authority. He is bounded by the law of precedent. And once a case has been settled by a Supreme Court or the apex court, then it has to be followed by each and every authority. and the binding effect of the order passed by a higher authority or tribunal of the superior jurisdiction. Let's say I'm talking of Delhi. So in something has been decided on the similar kind of matter, let's say by the tribunal Delhi, State Delhi, then that is binding on all the authorities coming below him, or authorities, juniors, I should not say, authorities that has to be deciding the matter before reaching the tribunal. So let's say Commissioner Appeal or even the Assistant Commissioner. So they are bounded by the judicial pronouncement that has been decided by Delhi Tribunal. Similarly, if something has been decided by High Court, so that is being, again, that has to be followed by Tribunal also. And if something has been decided by Apex Court, so then it has to be followed pan-India. The Honorable Supreme Court, in case of Commissioner versus Novapam Industries, had said it is settled law that the department, having accepted the principle laid down in the earlier cases, cannot be permitted to take a contra stand in the subsequent case. So they are not free that in some case they will say, okay, we will decide this particular matter in this manner, and on the same facts they cannot say that, okay, this time we will be deciding the matter in this manner. No, once they have taken a stand, so they have to abide by their own stand, and they cannot take a contrary stand with the similar kind of facts in some other case. Doctrine of merger, it says it's a common law and both the parties are using this provision. So that means which is founded on the principle of propriety in the hierarchy of the justice delivery system. The underlying logic of doctrine of merger is that there cannot be more than one decree or an operative order governing the same matter, subject matter, at a given point of time. So let's say if I've just given an example of input services that has been, let's say, decided by an high court as of now. Just think that in case that has been settled by an apex court, so then there cannot be any other provision, or there cannot be any other kind of order with respect to these kind of issues, or with respect to the matter involving input services. So it has to be decided in same order, and that will be binding on all. Obiter dictum. So this expression means opinion on a point which is not necessary for a decision of a case. This very definition draws a very clear distinction between a point which is necessary for the determination of a case and a point which is not necessary for the determination of the case. But in both cases, point must arise for the determination of the tribunal. Two questions may arise before a court for its determination. The court may determine both, although only one of them may be necessary for the ultimate decision. So there may be issues. At times we say if something is very important issue, or that is the secondary issue. So primary issue and a secondary issue, and court may determine both the issues, primary and secondary, but only primary issues may be taken up for deciding a particular matter. The question which is necessary, or which was necessary for the determination of the case, would be the ratio decidendi. The opinion of the tribunal on the question which was not necessary to decide would be an obiter dictum. So you have to understand that, okay, there may be a secondary issues also, but whatever is being decided and the important aspect of that case has to be dealt with. So they will be forming the primary points for that determination, and other will be falling as an obiter dictum. Now, what is ratio decidendi? I've just seen ratio decidendi is a Latin term which means the reason for the decision. So as we have seen that primary points are being taken. So why they have decided a particular case in a particular manner. So they will be saying that, okay, these are the reasons, or these are the points or the reasons for deciding the case in a particular manner, and refers to the statement of the critical facts and the law of the case. These are the vital to the court's decision itself. These are vitals to the court's decision itself. Obiter dicta are additional observation, remarks, opinion on other issues made by the judge. These often explain the court's rationale in coming to that particular decision. So they are like your allied, or they are like your auxiliaries that are helping any court to decide a particular case in a particular manner. And while they may offer a guidance in similar matters in future also. So we can see that if I read that whole judgment of VKC Footsteps, so I can understand what were the main point that took where the court took the assistance of those points in deciding a particular matter in a particular manner, and what are the other allied or auxiliary points that has been taken care while reaching that decision. So in case I have seen that, okay, he has referred to these notification. So on the similar line of the of any other litigation issue, I can also refer that, okay, the contention of the court while discussion was going on or while the case was being heard in the court. So these were the points that were referred. These were the issues that were taken care of. These were the main points, or these were the secondary or the ancillary points. So with this, we come to an end on this issue that we have discussed on the summons, notices, and how they have to be dealt, how you have to draft a reply, what are the important aspects that should be taken care of. Now we are opening the house for the questions. So in case you have any queries regarding to how to draft, how to deal with the summons, how to deal with the notice, then you are free to ask.
So there was a question by Balaji. He's asked that three chances to be given before passing the order, a rejection order, like before rejecting any refund. So there must be any three chances to be given. So I think these
No.
three chances are in respect of personal hearing, not in respect of the Shokos
Personal
notice.
hearing and three chances deals with the number of adjudication, adjournment that you can seek in case of a appeal or in
Right.
case of a personal hearing, basically. And with respect to refund, they will be issuing a show cause notice, and for that show cause notice, once you have given the reply, then they will give you an opportunity of personal hearing, and there is no such restriction that only 3 hearings has to be given. So in case your matter is not completed or your submission is not completed in one hearing, you can always request for the further hearing or the further date for a
Submissions,
new hearing.
further
Yes,
submissions as well. Now, apart from it,
submission. Yes, for the submission.
Sabyasachi have asked that if Shoko's notice is not containing relevant provisions of law, so then we can we challenge it, or should we consider the notice invalid? So I don't think so. There is anything written in the law regarding this, but as per the judicial precedents which have been shared by Archana ji as well, and there have been many judgments in this regard. As I said as well, that Shoko's notice must be complete. It must contain the relevant provisions, must contain the exact allegations which are they're trying to do. So you can challenge these kind of notices directly before high courts as well, if you feel that is the notice is completely wrong or invalid.
And Navjot, we are seeing, like, if I just give a very small example of ocean freight. Ocean
Hmm.
freight is a well settled issue now on exports. We all know in service tax also there was no service tax liability on ocean freight. But till date, we are receiving the show cause notices. I mean, the logistics
Right.
companies are still receiving the show cause noticing on this issue only, which is well settled issue from majority of the tribunals also. And even now, we have seen that even the first adjudicating authority is also giving orders in the favor of the SSC. But still, that issue is persistently, I mean, taken up by the department. So we cannot say that something that has been settled or something that has been very clearly defined, because again they are doing whatever is in the best interest of the revenue. So I mean, nobody will be challenging that why you have issued a show cause notice. And we have seen almost, if I'm not exaggerating the the data, 90% of the show cause notices are quashed or they are against the revenue when they reach tribunal.
Right.
So we can understand that whatever the show cause notice is are issued today, generally they are issued which may not see a day of light once they have reached the tribunal level. And majority of the show cause notices are taking a turn towards the assessee when they reach the tribunal level.
Hmm. Also, Sabyasachi question I think misread by me. He said that when department is issued notices, which is not a Shokos notice, basically, and they are just issuing a kind of a intimation without mentioning any provisions. So that is the basic principle, Sabyasachi, as I mentioned, sine qua non, that it is a mandatory requirement that before proceeding to any demand proceedings, it is mandatory to issue the Shokos notice. I think that's what you're trying to mean.
And Sachi, we can always say that, okay, in case you have received some kind of communication where proper section is not mentioned or proper reference to some legal statute is not being mentioned, You can always reply, and you can always ask, I mean, under which section I have to give the reply. I mean, I'm not able to understand under which section I have to properly give the reply, or under which section you have invoked this. So there is no bar in raising these questions, so that tomorrow again, as we have said, that tomorrow that should not be taken against you in case there is a defect. So you are legally, you have the right to question that defect, so that you are using your power which has been enshrined to you through the statute.
Right. And we mentioned, Sabyasachi, we mentioned in previous session of classification as well that we don't need to rush to high courts for every matter. Firstly, we can see that if that thing is can be manageable at adjudicating authority, so you should try to manage it at that level only. I'm not saying you to not to exercise your right, which is given by Constitution under Article 2 to 6, but practically high courts cannot take away the right from adjudicating authority from actually adjudicating anything. So they won't ask him to stop there. So like whenever we see the correct format is not being used by the department, or maybe they have not used the correct form, like the medium of issuing the Shokos notice. So then when we go to the high court, so what high court does is they tell the department to do it in the correct way.
Yeah.
So that's what they do.
Yes,
So
yes. They will not interfere in more than that. In case even if I rush and say, okay, he has summoned me this and it is beyond his jurisdiction, or he has summoned directly to the director. So what High Court will do at the max? Okay, he'll instruct the department, okay, kindly take care of the replies or kindly take care of the submission, and in still you require his presence, then suffice that matter or suffice your requirement, and accordingly you will be able to they will allow him also that okay, you may call directors or any other officials whom you may deem fit, but okay, you have to
right,
give me a requirement, because
right,
yes, this is a procedure that, and we have to see that by giving this powers, I'm not saying that there should not be any power to the department, because otherwise then there will not be any kind of control on the non compliant person. So in case you are a bona fide, you don't have any kind of things to be hidden from the department, then you are always free to challenge those things, and you can always challenge the show cause notice, or you can always challenge the summon, or you can always give a proper reply, or you can always give that okay, this is beyond your jurisdiction. Because when someone has all the facts intact and when the case is strong, then only we suggest these kind of things. When your hands are not clean, we'll never ever suggest anyone to go and bang the door of high court, or even go and bang the doors of the jurisdiction officers also, because you
right.
have to be really very clean handed when you have to go and challenge these kind of things that are being issued through the department.
Exactly. So we can conclude our today's webinar by mentioning three important points. First one is you need to take care of the Shokos notice. You need to read it carefully. You need to reply it with utmost care. Second, from Shokos notice, it is very important to respond to the summons. They are more dangerous in nature. They are, I would say, this is a one-page dangerous document which they issue. Like Shokos, you might be getting the Shokos in 50 to 60 pages, but ultimately you'll get the order after that. But in summons, there might be some other proceedings as well which might be initiated against you. So these things can be taken care of. Apart from it, if anyone is having any issues regarding, or they are like facing any issues, so you can free feel to reach us. Our information is there on the screen. We are happy to help.
So I think we should wind up.
Yeah.
So thank you to ConsultEase for giving this wonderful opportunity, so that we are able to interact with the learned audience, and we are able to share whatever little knowledge we have gained through this process of our professional journey. So shall we leave, Navjot?
Yeah, I'm just seeing that only.